Mics are hot.
Yeah, no, I figured that out.
All right, well, shall we get started?
Absolutely.
Great. Let's do it. Thank you all for coming. Welcome to this discussion co-hosted by Above the Law and the Samuelson Clinic for Law, Technology, and Public Policy at Berkeley Law School. I'm Crump, Director of the Samuelson Clinic, and the clinic works to advance the public interest in a digital age marked by rapid technological change. We provide Berkeley Law students with the opportunity to work on cases at the intersection of technology and civil liberties and other issues while they in law school. With me are Ken White and Mystal. Elie is the executive editor at Above the Law and Intern Law, and Ken is a First Amendment litigator and criminal defense attorney at Brown, White, and Osborn, but maybe even better known as a Twitter presence in So this event came together because back in August, Samuelson Clinic supervising attorney Megan Graham was looking for a good example of a question for our students to consider when discussing what is in the public interest. And she came across this heated discussion on Twitter between Ken and Elie about this billboard posted by a gun shop depicting the squad, the four freshman women congressmen of color, in a manner that suggested that they might themselves be a good reason to buy a gun to arm yourself. And they were talking about the First Amendment, and Megan said, "Hey, this is great. We're going to use this in our class." And Ken said, "Well, why don't you invite us to Berkeley to do it live?" So here we are. We took him up on it, and thank you, Megan, for that. I want to set just a bit of context. The question about the extent to which the First Amendment protects hateful speech has been debated for a long time. But I would say the current debate over this really took a turn in Charlottesville in 2017. There was a march there called Unite the Right. People, it was a white nationalist protest, ostensibly protesting the removal or attempted removal of a statue of Confederate General Robert Elie. There was the white nationalist protesters. They were confronted by some counter-protesters. The event turned violent, and ultimately one of the white nationalists ran his car into the crowd, killing a 32-year-old woman and injuring 20 others. And I think that event galvanized a lot of people on the left to start thinking about free speech differently than they had before. The current president and his often racist views are obviously a huge factor in this. And I have to say my connection to this also stems from the fact that the organization that had fought to make sure that the Unite the Right protesters could maintain their permit in downtown Charlottesville was the ACLU of Virginia, and I had spent almost 9 years at the ACLU as a First Amendment attorney. And the ACLU ended up taking a lot of criticism for this. Some people saying they had blood on their hands, and other people in the ACLU said that it would take into account not just the First Amendment value of case, but also the identity of the people who were being spoken against. Other people accuse the ACLU of betraying its own health values. So it's just that background to make sure we're all on the same page. I wanted to turn to the two of you, and maybe to you first, Elie. So what's your problem with how the First Amendment is being interpreted today, particularly when it comes to hateful speech?
Yeah, so thank you for having me. Thank you for that question. That is why we are here, right? And as a black journalist, I like the First Amendment, okay? Like, I say mean things about Republicans who could crush me. I like the First Amendment very much. I am not here today to crap all over the First Amendment. I understand exactly how important it is. However, I live in a world where I have become increasingly sick of what I would term First Amendment absolutists. People who think that in order to protect the free speech right that I must have in order to do my job, we have to protect all of it. That there's no meaningful distinction that can be drawn between what I do to make a living, which, okay, sometimes they're just dick jokes about Republicans, I get it. I'm not saying that I have the highest calling possible, right? But in order to protect what I do every day, we have to protect the Klan. We have to protect the Unite the Right people. We have to protect people on Twitter who are inciting violence against Congress people of color. I simply do not, I no longer agree with the absolutist position on the First Amendment. I think we must try to find some way to protect the parts, to protect the speech that we find particularly important, political speech, and deal with speech that has little or no value, which is hate speech, right? And I would go back to, before I give it over to Ken, I would go back to the simple issue in my mind. The First Amendment was written by slaveholders who were trying to make sure that their little crappy pamphlets couldn't be stomped on by the king. It was empowered by 20th century white men who really thought that the government could do all kinds of things to quell free speech, but actually arresting war protesters was not the most highest best use of the government, right? So we have an 18th century text inspired by 20th century white men, and at no point in that story did 21st century people of color acting as they should have always been allowed to be as full and equal citizens in society. At no point in that story did we get to weigh in on how the First Amendment should be interpreted. And so at the very least, I think we need to interpret the First Amendment within the context that there are non-white, non-men, non-Christians living in this country who deserve a say in how this particular area of law goes down.
Thank you very much for having me here. It's a privilege to be here from an institution that rejected me not once but twice. I agree with them. The context matters. It's a context of the America we have, not the one we would like to think we have. It's the context of an America that does treat people very differently based on the color of their skin. And I would maintain the reason that I would not say I'm an First Amendment absolutist. There are very few of those really living in the wild. But that I bring my sensibility as a criminal defense attorney to my work as a First Amendment litigator, being extremely skeptical and extremely jealous of any power that we give to the government to punish speech. The reason for that is I think in the United States of America, people in power are always going to be more threatened by my friend Elie being outraged than they are threatened by the things that outrage him. I would like to illustrate that with a slide. Look at the two pictures, please. Yeah, sorry. Yes. Here you see a slide on the left. You can barely see a young man we only know as Emmanuel, 15 years old. He knocked over a trash can at the group home where he lives because his parents abandoned him. Police officer came, found him insufficiently deferential, and tackled him, which was not a terrible challenge since Emmanuel has no arms and no legs. We don't know the officer's name. On the right, you see Colin Kaepernick and one of his teammates, people kneeling to protest things like the image on the left. I fight very hard for the First Amendment because I'm acutely aware that we live in a country where people are more outraged by the image on the right than they are by the image on the left, and more likely to try to suppress it.
Can we just push back right there? Okay, so totally, I agree. I stand with Cap, but I don't watch the NFL. I mean, it's on. But I don't go out looking for it. I don't have a fantasy team anymore, technically. Anyway, point is that I agree with you, right? But Colin Kaepernick still doesn't have a job, right? Like, the forces that are arrayed to stop this kind of speech, to punish this kind of speech, to make things harder for people like me to have my full free speech, those forces are already on the march and empowered and doing everything that they can to keep people like Kaepernick from voicing their opinions, right? So there is an aspect here where, like, the harm that you wish to avoid is already taking place. And it is in your attempt to avoid that harm that other harms that we could actually be stopping or we could actually be trying to do something about are allowed to continue under the rubric of we've got to make things safe for Colin Kaepernick. It's not safe for Colin Kaepernick. And he already knows that, and he knows that he's taking his career into his hands every time he puts his knee down on the football field.
And I'm not saying that we should take up the sword against bigotry. I'm advocating that we not hand the sword to the people trying to fight.
Well, both of you said frequently that context matters. So let's talk about this issue in the context of some specific examples. And let's start with the one that led us all to be here to begin with, which is this billboard that I've now displayed. Right, it was posted by a gun shop, Cherokee Guns. It references the four horsemen, which is obviously a reference from the Bible, the book of Revelations. The four horsemen were said to presage the end of the world, right? Cometh caused out by our idiots, right? And is speech here. So, Ken, what is the value of this speech? If the First Amendment protects this, why should it?
So I don't know that we need to value it. It's a mode of communication, and the First Amendment represents a judgment that we're not going to have the government weigh it and make decisions about its value. That people are going to do that and respond and engage in response speech to do that value. So what the Supreme Court has said is that the First Amendment already represents a value judgment, except for things that fall into very specific and well-defined exceptions. Then we've already done the valuing and decided that we're not going to give the government the power to punish it for a variety of reasons. And I think that is the value, not that the speech has any value that I carried away, but that I definitely see the value of not giving the government that power to weigh it, that power to make the decision about what speech is good and what isn't. Because I firmly believe that that is very rarely going to be going the way you'd like it to go.
Now, what I would say is that the reason why we are here with this billboard, the reason why this billboard is legal, is more or less because of a case called Brandenburg VO, right? Like this is how we decided. This is back in the war protest. Sorry, not in the war protest context. This is back in the context of a Klan rally where they were doing their Klan thing, and there was a camera crew, and Ohio had a really restrictive law about exactly this kind of. Was it sedition? Is that what they named it? They had a very tight statute trying to outlaw the Klan, or at least Klan-like activities. And so the Klan people were arrested, and they sued, and it went up to the Supreme Court. The Supreme Court changed our interpretation of the First Amendment, which before Brandenburg had allowed for these kinds of laws to say that you could not arrest, you could not devalue the speech. You could not arrest somebody for incitement unless two things were shown. One is that the threat of harm has to be imminent, and the other that it has to be obvious to a reasonable listener. And both of those prongs are crap. If I get nothing else across, it is my belief that the incitement law, as we currently understand it, is full of crap. It requires the nexus between the offensive speech and the harm to be right up against each other, right? It's got to be a one-to-one thing. So like, you gotta have the gun right now, and you're gonna be about to shoot her. I'm gonna be like, you should totally shoot her. Before we can kind of really get into getting me for incitement, right? If I'm sitting here and saying like, you know what you should do? You should buy a gun and go shoot. Like that's attenuated. That wouldn't be, that might be true threat, but that wouldn't be within our kind of current understanding of incitement. So I think that we need to understand in the modern world that the inciting speech and the eventual bad act can be more attenuated than they contemplated in Brandenburg. And the second thing, and we've discussed this as well, I do not care about your reasonable white man standard. Because again, to me, this goes back to a refusal and a blind spot where we look at the law through the lens of a so-called reasonable white person, and we have not updated our law to think about it from the perspective of a reasonable person of color who is likely to be under threat from this kind of speech.
Well, and in fact, with our convention, that's how some people took this, right? You see it for example, wait, how the hell is this not inciting violence? So again.
So well, the test, as Elie said, is does this speech, is it intended and likely to cause imminent lawless action? One place where I disagree with Elie is that I think that our understanding of imminence can change over time. Our understanding of imminence can change with technology. Something that we might not have imagined, like something said on Twitter, could have an imminence element that before would not be imagined. I think that the way that the law develops on this, as it does develop, is that the people making decisions and jurors are going to be informed by their life experiences about what is or isn't imminent. My main concern is that under the rule of law, we apply the test. Is this imminent? If you want to make the argument that this is imminent, I'm great engaging on that level. What I'm not great about is throwing out all the rules and giving the power to a government that currently thinks that Black Lives Matter is causing cops to get killed.
I would say that we need to change the law through the acts of Congress, not through the jury. Because if there's one person I don't trust in this situation, it is the dumbass jury. Like I fear juries like as much as possible. Like I would rather have this go through Pelosi and Meadows and then Warren's gonna win, we're gonna kill the filibuster. So be fine. It's totally gonna be fine. So I don't have to worry about that. But you see what I'm saying? Like I would actually rather have like actual professionals thinking about this as opposed to a jury which killed Gawker because Hulk Hogan was involved. Like juries are a problem in this area generally speaking.
But Elie, you've got a country where a vast majority of people polled on the Republican side said that CNN was more dangerous to America than Ku Klux Klan. Those are the people making some of these decisions. And that's why I think there has to be a standard. What I'm saying is that our understanding of how that standard applies ripens over time as our experiences change and as more people who didn't traditionally have a voice in that discussion become part of the discussion.
And that's the end of the law isn't going to happen when I sue Trump for defamation because I've opened up the libel laws, but that's what
Alright, well, should we move on to another example?
but just before we get off this, I just want to say one more thing. Because look, Ken and I agree. Fundamentally, this poster under the current law is not illegal. Like just fun. Like there's no standard that we have yet that would make this illegal. And even in my kind of like argument for understanding a more attenuated link between the inciting speech and the action, it's going to be hard for anybody to get to the point where an ad, something that's clearly an ad, something that's clearly intended as commercial speech, ever kind of comes into the purview of what I'm talking about. And I point that out not to like weaken my own argument, but just to what I think I'm doing is reminding people that I'm not a crazy person, right? Like there's still a lot of very, very bad speech that is valueless that would still be allowable even under a more kind of aggressive interpretation along the lines that I'm going for. And I point that out to say that like it's not like you agree with me and then the walls come down and then we're all living in 1984, right? No, that's not. It does. There is the slippery slope doesn't slope that way, right? Yeah, you could probably get away in an ad talking crap about Congress people. Like that's probably gonna still be okay. I'm just saying that what happened here is that it allows us to think about the difference between incitement and the action a little bit differently than we usually think about it, and I want to extend that time.
Doesn't the slope that way though? Because I mean, I would say the wolf is always at the door, and it's not the wolf you think. It's not like if we do this, all of a sudden, all sorts of people who want to put up racist billboards are going to be for it. Think about the types of laws that have been proposed in this country for the last 3 years, and think about the way some of you, as college students, have been used as political tools, as examples to get votes and about hate. The last few years, after the Black Lives Matter marches, things like that, saw 12 states pass laws making it easier to expel students for interfering with speeches at schools, for counter-protesting. It saw 3 states consider laws making it legal to run over a protester if they block you in the street. It has police increasingly employing laws that protect them as if they are victims of hate crimes and hate hate speech. That is the wolf at the door, and I don't believe in a system where if we ratchet it back and we make it easier to do this type of rhetoric, that this is the type of rhetoric that's actually going to get targeted.
That's the wolf at the door, but the wolf is already inside the house. The call is coming from inside the house, man. Like, we're already there, right? Like the issue is not all of the things that you just said are happening regardless of our current understanding of the First Amendment. The First Amendment is not going to help us stop that. Stopping racists will help us stop that, and I'm the one who's trying to make it harder eventually, as we will get to this, trying to make it harder for them to like organize and find hate and come from online.
Well, since we're on a college campus, shall we talk about speech on college campuses?
Sure.
Okay, so this is our next example.
Jeff Sessions would say, all you can say as long as you don't boo me, man, it's all good. I don't like Jeff Sessions.
This is an example of an incident that occurred at the University of Connecticut. I'm going to play this video, but the audio is probably going to be too quiet for you, so I'll describe it to you. Three white students were walking through a parking lot near the University of Connecticut apartment complex. Two of them appeared to have been involved in some sort of game in which they shouted offensive words more and more loudly as they went along. They started off in juvenile fashion with the word penis, but then proceeded to move on to shouting the N-word as loud as they could. Little did they know they were being videoed as they do this. A black student was looking out the window and shot this video when the students going through the parking lot were saying this word. He didn't know whether they were directing it at him or not. Ultimately, the campus police ended up arresting the two students who were engaged in this game and charging them with violating Connecticut's hate crime statute. So, Elie, this goes too far, right?
It's pretty aggressive, right? That's pretty aggressive. Look, I hate this question. I have a couple of ways of answering it. I'll throw one out there and just start because I think it's the easiest way for people to get to where I'm thinking. Okay, so probably arresting the people and throwing them in the hole is not the right idea. However, throwing them for a night in Okie, and then letting them out, and then throwing a fastball by their face is not the worst outcome. It's not the worst outcome in the world. It's not bad to me that they had like a bad night in jail. Is this the kind of thing where we should, as a matter of course, arrest people simply for saying the N-word, one magic word, above all else, is the one that can get you actually arrested? That's not a world that I think we can, I don't think that world works. Unless, and this is my second thing, this is all throw to you, unless we want to argue, and I can make the argument as well, although it's hard, unless we want to argue true threat. So I said earlier with the AOC thing, that there are two things involved here, right? There's the incitement issue, right? And Brandenburg tells us what incitement is. The other way that we find speech unprotected is if it's a true threat. So it has to be a direct, kind of truly understood, like you are threatening my life and harm and safety and whatever. And if I can prove that it's a true threat, then you don't have a protected speech right to threaten me, essentially, right? And I can make an argument that the N-word, by its very nature, is a true threat to any African American that you say it to. Here it's tough because he wasn't saying it to. It gets murky, right? But I can at least start to kind of imagine making the argument that, like, if you roll in here and you call me the N-word, you are threatening me, and that therefore that speech is not protected, and therefore he pays you money, he takes the chances. I can argue. So that's kind of how I get there, right? Like we probably can't have a world in which you get arrested for a word. If you got arrested for a word and you got let go, I'm not going to cry about it. And certainly at the point where you were using that word to threaten people, I am happy to bring the hammer down.
Like any other person, I'm also tempted occasionally by the he had a common exception to the First Amendment. But
that's not the fighting words exception. That's straight up just like you deserve it.
So let's talk about this law, because these discussions should always go back to actually what the law is, what the tool is that's being used. This is Connecticut law, and I'm going to go to the text because I'm a geek and because that's where you go. It says any person who by his advertisement ridicules or holds up to contempt any person or class of persons or on account of the creed, religion, color, denomination, nationality, or race of such person is guilty of a misdemeanor. Now, the first thing you need to know is this law is actually about those no Irish name apply signs, turn of the 20th century. So it's not for this at all. It says advertisements in it. I would sue the cops for arresting the guy in 1983 and I would win because they had absolutely no basis to arrest him. The second thing I would point out is you need to look at how the law is used. And this kind of goes in the direction that I've been talking about. Eugene Volokh at UCLA pulled all the cases under this particular statute that he could find. And would you like to guess, 25% of the prosecutions were in defense of one particular group being ridiculed. Anyone want to guess what that group is? Yep, the thin blue line. 25% of the cases were about police being called things like you bald-headed cracker, the second half of which at least is protected by the First Amendment, and things like that. A large amount of the rest was brought to bear against homeless people, mentally ill people, generally people who are causing trouble in public. It is not used in Charlottesville type situations. It is not used in a sort of true threat situation. It is used as a tool of power by the police, often against insults against them, because that is the way that exceptions to free speech are used by the government. And that's it from the very beginning. And let me just give one example before I throw it back to you. Elie's right to talk about true threats. And I could imagine a scenario where using racial epithets could be a true threat. So a true threat is when you say something that a reasonable person would interpret as a genuine statement of intent to do harm, and that you had some level of intent would be taken that way, okay? So I can imagine confronting somebody and calling them that name, putting them in fear of danger. But again, true threats doctrine didn't happen because of situations like Charlottesville. We get the true threats test from Watts versus United States, because Robert Watts, an African-American man, was at a war protest. Someone told him you ought to get educated before you state your opinion about these things. And he says, if I'm ever drafted, the first guy I'm going to give my sights is LBJ. And so, of course, they prosecute him because rhetorical hyperbole by a black man is more threatening than actually killing 50,000 Americans in Vietnam.
Yeah, so that's great. My pushback on what you say, again, you're fundamentally right here that like the Connecticut law, that's crap. You can't have it. This arrest, it's not a good arrest. But what you haven't done, and where we eventually need to go, is you have to explain to me how I can stop the guy from shouting the N-word in the middle of the parking lot, because that has to stop. And when you say that it can't stop, that is what makes people say, you know what, let's start opening up Bible laws. Let's start messing around with true threat. Let's start doing all of these things that you say would lead to danger and badness. Like, okay, you don't want to go down that road to all of these bad outcomes, then tell me how to stop the guy. Because that guy has to be stopped.
So if he's saying it to your face, that falls into what tiny little sliver of the fighting room's doctrine survives. A face-to-face insult likely to provoke a fight from the particular person who's doing it. Okay? That can be punished almost certainly. It could also be, as I said, a true threat, because I think if you have some nutcase rolling up on you and throwing racial epithets in your face, many people would interpret that as a threat that he's imminently going to do harm to you. In some circumstances, it could be incitement. If he's got a crowd behind his back and he's doing it, he's trying to get them riled up, that could be clear and present danger. That could show that he intends and is likely to cause a violent reaction. We can see from Charlottesville that there were prosecutions of violence and of conspiracy and things like that. There were a lot of situations in Charlottesville that could be punished for speech because of the context. So if you give me a context, I think that some of these things you're talking about can be punished.
And that's why I'm saying we have to open up, we have to stretch it a little bit, so that you can get more of this speech punished, right? And that's why I say you have to think a little bit more creatively about true threat in the way it's currently applied. You have to think a little bit more creatively about incitement in the way that's currently applied. Because if you hold towards this issue of evidence, I think, is a big part of the problem. Where it really has to be something that you're afraid of happening to you right now. And I feel like that's a problem because you shouldn't be able to stop the speech once they start shooting. You shouldn't have to wait until they start shooting before you can stop the speech. That is clearly going to lead to the shots.
Sure. So the question is, though, and as a criminal defense lawyer, I'm not fond of thinking about the government being creative about things.
Fair. This is correct.
So I just think historically, wiggle room here is not used in favor of protecting people from racist or abusive speech. Take fighting words. Now you know the background of fighting words as well as I do. Or I'm sorry, I'm the guy that you resent agreeing with. Warren Shaplinski, Jehovah's Witness, living in a time when America had absolutely brutal bigotry against Jehovah's Witnesses that we've mostly forgotten about. He's preaching on a street corner, a crowd gathers around him, they're reviling, they're threatening him. A guy comes up and tries to run him through with a flagpole.
Like literally there's a Simpsons episode.
Right. And so the cops come and say, okay, we're taking you away, you gotta stop. And he's mad. So he says, you're a goddamn racketeer and a fascist. And everyone here in Rochester is a goddamn racketeer and a fascist. It's true, I've been there. And so of course they prosecute him. They prosecute him, the religious minority who is being attacked because his outrage is more offensive to America than the abuse he was taking. And I cannot conceive of a system where if we get that wiggle room you're talking about, that's not the way it's applied.
I can conceive of one. This is hard.
So since we run a technology law and policy clinic, I have to ask you about one question about online free speech that endless harass YouTube really every day. But I'll ask a pretty narrow question. So I want to talk about the Second Circuit's decision in the Knight Institute at Columbia University case. So President Donald Trump has a Twitter feed. You probably have heard of that. And he has blocked certain individuals on his feed. And some of those people sued, saying that they had been prohibited from being able to participate in speech. And the Second Circuit agreed with them, saying that the First Amendment prohibits public officials who use their Twitter feed for public purposes from then blocking people on account of their viewpoints. Now, he's not the only politician who blocks people on account of their viewpoint, it seems. So Alexandria Ocasio-Cortez has also blocked some followers, and the same institute, the Knight Institute, wrote down and said, you should not do this. And her response was basically, I am a woman politician in public life, I'm a woman of color, I get harassed by people, and it shouldn't be that the cost of my participating in this debate is that I have to suffer all of these abuses from these people. So maybe I'll start with you, Ken. Why is she wrong?
She's not wrong, I think. And this is just an example of how law always lags behind technology. Our understanding of how they merge is always 20 years behind the tech. So I was fairly skeptical of this idea, this right not to be blocked. And I have to say I've come around a little bit in reading the actual opinions. So the idea of it is that the government can't kick you out of a public forum because it doesn't like your viewpoint. And the idea is that when a public official uses Twitter or Facebook or whatever for official purposes, then they're creating a mini public forum in the wake of their tweet or their post that people can have discussions in and respond to. And that they can't block you from that forum because they don't like your viewpoints. Just like if your town were holding a town meeting in a rented hall, they couldn't ask the person who owned the place to kick you out because they didn't like who you were voting for. Now, I think what saves this from being a complete horror show that would fall mostly, I think, predominantly on women, is that you can mute people. what you can't do is, because of the specific technology, is block them so that they can't respond to the president's or AOC's tweets. And the rule is somewhat narrow in that it says that Trump basically conceded that he blocked these people because of their viewpoints, their disagreement with him, and their speech.
Because he has terrible trades record at all times.
Yes, I think Giuliani came with that one specifically, and that their speech was protected by the First Amendment. So I think there is leeway here for abuse to be met by minimal with abuse, possibly by a block as well. Of course, the part that's really open to abuse in America is that our legal system is such a horror show that people can sue you if you block them, or even perhaps mute them. It's only a matter of time before someone makes that argument, and harass them in that way by subjecting them to constant litigation.
Yeah, so I think that's right. I generally agree. I'm actually surprised that you're here, that you came around on the muting things. I do think that's important. Certainly one of the big moments for me when I got off a little bit of the First Amendment absolutist train was in terms. So if you were a long time reader of Berkeley Law, you know we used to have open comments, and we no longer have open comments. And it turns out, most people don't know this, so a little bit off the record here, I was the last holder. So like everybody else actually had gotten to the point where they were like, no, we should block them. I was like, no. Even though I was like the subject of quite a lot of the worst comments, I felt very strongly, look, it's a deal. Like you read my thing for 15 minutes and you can say whatever you want from me. I'm big white and take it. Whatever. This was proceeding from the false assumption that 8 years, 9 years in, I was still getting the worst of the comments, and I wasn't. It was the women who worked for my side that were getting the worst of the comments. And as I started to read their comments, that sense that like it just cannot be so that a part of them doing their job is to read this crap. Like I might take that on for myself, but I can't, as in a managerial role, make any of my kind of colleagues or employees do that for themselves. Like that's just wrong. So that really is when I was one of the first times that I kind of started to come around that maybe all free speech is not great speech, right? So I'm all about the muting. I think that's important. I come at it from a slightly different standpoint, though. Speaking of the Knight Institute, Tim Wu has a really interesting article on there, and it's all about how our interpretation of the First Amendment has been so on the individual rights aspect of it, your personal right to free speech, which was not the only way we could go. As I've alluded to before, so much of our current free speech interpretation came up through World War I, and just, people protesting World War I, and people like Oliver Wendell Holmes and Leonard Hand, and eventually Justice Brandeis being very annoyed that the government was stamping down people's free speech. Well, that was one thing that was happening during World War I, and that was the direction that Hand wanted that side to go. Another way of handling it was the fact that at that time, Woodrow Wilson was, running a government propaganda ministry, right? Like we've had ministry of propaganda in this country since long before Kellyanne Conway got a job, right? Like this has been a constant thing rolling in our society. And one way of thinking about free speech is not just through the individual rights aspect of it, right? But it's in the same way that we think about the Establishment Clause, which is also in the first goddamn amendment, right? The ability of the government to establish religion, we understand, Gorsuch and Alito, Kavanaugh aside, Thomas aside, we generally understand that the government should not be in the role of promoting one religion or another. In the same way, one can imagine, again, we're not anywhere close to them yet, but one can imagine really thinking about speech in this new world with this new technology as the government not censoring speech by prohibiting people from having access to speech, but by drowning out the speech of their adversaries with a dedicated troll army, say nothing of getting outside influence. Like Donald Trump is able to completely change the narrative of what the news media is through the force of his Twitter account, and one can imagine a First Amendment that would find that to be problematic in terms of the government using speech to effectively drown out the rights of the press, right? So, and again, I'm not saying that we're there yet, and this is it's a law review article, and unlike a FedSoc people, I don't cite law review articles when I'm making a case, okay? Like, it's just a thought, it's not a thing. But my point when you come back to whether or not Trump can block people on Twitter, how that should all work, it is clear that we need an update into how we think about First Amendment law to respond, and the government's action around First Amendment law to respond to the technologies that everybody has in their fingertips. The democratization of media requires new, different, innovative responses to what we're seeing.
To me, this is related to another hot tech First Amendment issue, and that is the wave of cases trying to force the Twitters and Facebooks of the world not to kick people off. This idea that you have some sort of First Amendment right not to be banned from Twitter if you're a racist dick. And to me, where I depart from some of the First Amendment people on this is I think that the right to free speech absolutely has to include the right not to talk to people you don't like. The right to free expression is held up only by individuals, but by companies and organizations, and they absolutely have the right to create a type of platform that doesn't have people like that. That's freedom of association. That's definitely freedom of speech. And so I think as we develop this doctrine about not blocking, I think we have to keep our eye just as much on this doctrine that a really robust right not to interact with people that you don't want to.
But you're generally very skeptical of Facebook and Twitter being our new speech overlords.
I don't know what you mean by that.
So do you, I mean, what's the way to phrase the question? I do not typecast you as the kind of person who, when the deplatforming happens.
Deplatforming to me is those companies exercising their freedom of speech and freedom of association, creating the type of product that they want to offer, and then we vote with our feet as to which one. I mean, does everyone remember Club Penguin, the cute little thing for kids? I mean, Club Penguin gets to have a place where, Klansmen aren't running around screaming obscenities because they have the type of place they want. So do Facebook, so do Twitter. It's their free speech as much as it is mine to kick someone out of my living room if I don't want them there, if I don't want to talk to them.
Does that mean they can also have lying speech?
Well, within the limits of, has been defined, yes. There are relatively few areas where lying is not protected by the First Amendment, specifically in government, for instance.
So I would change that. There we go. I was trying to get you to the point where we disagree again. So yes,
okay.
I want to find a way to make sure. I want to regulate Facebook like a public utility, and thus make them not able to publish lies.
So, and the media shouldn't be able to lie either, right?
Oh, well, what do you call a lie?
Well, shall we ask President Trump?
Right. This is where I lose, right? No. It's a huge goddamn hole in an argument. Because obviously, I think that we should promote truth and de-promote and de-platform and de-emphasize lying. And I do believe that there is such a thing as objective truth, and half the country roughly disagrees with him. And I don't know what to do about that, right? Like he has so destabilized our common culture that you can't get half the country to agree on whether a fact is a fact, right? And so in this world where flat earthers are running the goddamn nation, I don't know how to craft a speech law that makes flat earth crap not available, but allows round earth science to be available, right? I don't know how to create that world when, 13% of the country thinks that the earth is flat. Like, I don't know who can live in such a state.
I just say we don't give them power to do it. And that we work hard to fight it on a personal level and a social level to fight back against that stuff. And no one said it would be easy.
Free speech is definitely.
Well, speaking of speech, I wanted to use some time for questions from all of you. Does anyone have a question they want to get us started with?
So, thank you both so much for being here. I think that one thing that's been really interesting to me is sort of this lens of criminality that we sort of have been looking at and analyzing the power to restrict speech. I wonder, though, how it would change both of the viewpoints
Yeah, no, I don't think it doesn't change my analysis very much because we actually you think we've been talking about criminality. I don't think that I've been talking about criminality very much at all, right? Like I don't think we haven't gotten to the punishment phase, and as much as I might sound a little bit more what's the word I'm looking for authoritarian when it comes to restrictions on speech, I go back into being a very good card-carrying liberal when it comes to over-incarceration, right? So, like, you give me a fundamental, non-violent crime, even if I think that it should be a crime, and you don't think, like, it's very hard for me to go from there to, like, jail forever. No, like, I'm not. So, in most of my thoughts, I'm thinking of, light, very, fines, and just, I want the shame. This all in here. I have a belief that for most people, jail is terrible. It's terrible. It's something to be avoided. You put most of these people in jail for 2 days, like that's enough jail for that, right? And so certainly, I don't think there's a whole lot of. If I want you to stop saying the N-word in the parking lot, and I got you in jail for a night, I've made my point. I don't need to have you in jail for the rest of your natural life.
I'm gonna have nightmares over this exception. So it's a great question. I think that free speech practically in America is under more danger from civil penalties than from criminal ones. Because it is so easy to sue people for harassing reasons and so easy to make the cost of speech completely unpayable. Look right now at Representative Devin Nunes suing people, including a satirical cow on Twitter, filing lawsuit after lawsuit. Right now, there is this trend of performative defamation lawsuits that are full of the type of rhetoric you'd expect at a campaign rally, and that are lashing out at people for explicitly political reasons. And that's always been the case. I mean, for God's sake, one of our chief First Amendment decisions, Sully versus New York, is about people covering the civil rights movement and people trying to inflict cost on them for doing that. So I think we have to be just as vigorous in the protection of speech in the civil context, because that is where most of us are more likely to live. We're more likely to get threatened by the crazy neighbor that they're going to sue us because of what we said about them on Facebook than we are to get hauled off to jail. And that can be extremely terrifying to debilitate people.
Yeah, you fix that with a federal anti-slap statute. You get golden.
There we go.
I mean, you do. I mean, look. Don't get me wrong. I am absolutely I write for a living, and I like to keep writing for a living. So I don't say crap about Peter Thiel. It's absolutely happened, right? I didn't go in on the Cutting the Boys. I saw that coming, right? Like, I'm worried about these lawsuits, so it does chill my free speech. But the way to fix it is not to, well, we must have just anti-slap, like really good federal anti-slap, and that will take care of it for now.
And then bring that
So, I wanted to just go back to the billboard because I think it's an illustrative example. So, I think it's very reasonable to not even see that as a come from gun country thing. I think it's racist, but I don't think it's saying target those people. I think it's the message to like anybody from gun-loving country is these people are coming to your guns. So I think it's illustrative of the danger of interpreting speech and then punishing it because you can have several interpretations. But how about if there were targets on them, like Roger Stone, right, and his crosshairs? So what if there were crosshairs over those four hundred?
I think that would be closer. I don't know if it would be all the way yet.
the questions were like.
Yes, of course. So the question is sort of looking at the billboard, how people from different cultures can take it completely differently. Someone who lives in a culture that's a lot more familiar and comfortable with guns might not see the gun element as threatening at all. Someone who comes from a culture where they've been threatened based on their race might take it a different way. And what if there were crosshairs on this? I think if there were crosshairs, it takes a big step towards true threat and possibly towards incitement. I don't think it gets there yet. I think it gets there close enough to get a visit from the Secret Service, but probably not yet over the line. What I think is really interesting, what we pointed out, is that it's precisely this vast difference in different cultures that tends to make speech laws very dangerous and easily abused. Because the way someone reacts to something can be completely divorced from the understanding of the people who said it, the community they live in. So there's this case down in Texas of this kid who was on League of Legends, an online game, and talking trash with other people in League of Legends. And one of them says, "You're crazy," and he says, "Yeah, I'm crazy. I'm going to go shoot up a school. I'm real crazy," something like that. Clearly, just online trash talking. Someone from Canada reads it. I guess an unusually polite person, even from Canada, thinks that this is terrible and takes it completely seriously, calls the cops. The kid spends a year pre-trial in jail for something I don't think anyone seriously thought was a genuine threat or anything other than juvenile trash talking. So we have these clashes all the time in America, and the problem is that it's usually the less dominant cultures that ones get the short end of that.
You see this a lot also with rap music, with rap lyrics. You have a lot of cases where people have been hauled up on where the evidence against them that they were attempted this or about to do that is a rap lyric that they repeated at their ex-wife or they were stalking and what have you. And it's, if you know anything about it, it's really funny sometimes. You'll see these justices or judges writing about rap music. They clearly have no idea what the hell they're talking about, right? If you have any kind of understanding of the culture of the music, you understand that these were not meant as true threats. So because of that, I do worry sometimes about. Again, I was kind of more focused on opening up incitement as opposed to opening up true threat because of some of these cultural issues. However, I also go back to my earlier point about how sick I am of the reasonable person standard, right? Like I would like to find a way to make the reasonable person standard not so much the reasonable listener of the speech, because then you get too much of whoa, I live in a country and we shoot these kinds of things all the time. Nobody would do it's for real. But you have some other kid who's just like, no, I think that it's real. I don't like that. I prefer trying to get to some objective standard that would look a little bit at kind of the reality and the likelihood of it happening, right? So, in this situation, Gabby Giffords is shot relatively recently off of this kind of rhetoric. Maybe not this specifically, but when you get to now their targets on them or whatever. I would find that to be much closer to something that the government should look into when you're dealing with something that has, objectively has really happened, as opposed to a guy, coming up here and being like, "Oh man, we should go down to Oakland and wow." It's like, oh, whatever. Like you're go ahead. I pity the Tucker Carlson going down to Oakland trying to smash some heads, right? That hasn't happened since the 1850s, right? So there's got to be some push pull. And again, the problem with all of my standards is that they're messy. They're messy, and they only work in a world in which judges and attorneys and people in charge are acting in good faith. And the biggest problem that I have with my arguments is that we live in a world of extreme bad faith, right? With just extreme examples of bad faith lawmakers and bad faith judges and bad faith cops doing bad faith things. And my standards only work if we have a world where everybody is kind of trying their best.
The woman with the red scarf.
I have a question. Do you see this kind of phenomenon on the internet and in Europe recently of kind of pushing things down and example like this sex trafficking, right? So we kind of ban certain types of activity and they emerge stronger than ever and are harder to police them. Do you foresee that kind of danger with the type of speech we're talking about? And I'll point to Germany specifically, where nationalism has emerged strong in strength this past election, and it evolved because to make itself acceptable to the point where it got beyond German law, which is very risky.
Yeah, no, and it's a good question though, because this is a live debate. This is a live debate within the African American community. Sometimes I hear people saying "I like my racists out in the open. At least we know who they are now." Man, I always knew who they were. I've lived having people call me the N-word and not call me the N-word. I'll take not calling me the N-word any day for 200, Alex. right? Like, think it all you goddamn want, but like, don't bring it to my face, right? Like that. So I worry less about it going underground, because one of the things that we've seen from the internet is that what it allows people to do is organize and feel accepted. If it's underground, they kind of still understand that it's shameful. They shouldn't be part of it. That, it's hard for them to organize if it's underground and not. But when it's out in the open and it's accepted, and they can go and they can say something on Twitter, and like 100 people are just like, I also think that black people like chicken sandwiches. What's up with that? Like then that becomes not something that should be like shamed, and you should like get that out of my face. But now you have like your little community of like fellow Nazis who think the same thing, and it becomes much more harder to shame them. And I generally think that for all of this stuff that we're talking about, like the social pressure against speech we don't like is always the best first option, right? Like before we get to the cops or the government or whatever, I also just like your mama to tell you like don't say that. Like that's the easiest way. And it doesn't happen when these people are out of there.
Yeah, I know people who make the argument that the reason that we don't want to suppress speech is that just drives it underground and can't monitor it. I don't find it particularly persuasive. I'm more in the camp of what Elie was saying earlier, that we're imperfect people, we're not actually all in good faith, we have problems, and we don't have, what it takes to implement rules like that fairly. So it might be true, it might not, I don't really have an opinion, but I don't find it persuasive as a reason to make censorship decisions.
I was wondering
sort of about what your take on incitement on the internet is, especially given that there's sort of the internet distance, so it's very easy to put this cover as like, oh, it's not really incitement, but it's clear that there are like when somebody gets doxxed, that's going to most easily lead to actual physical harm to the person being doxxed. How do you kind of parse that distance with the image likelihood that something is going to happen?
Can you start that because you explain how you actually, because there is such a thing as incitement that still can happen through the internet channels. Explain like what's required to get all the way there.
Well, sure. It's going to be the same test legally under current law, where you have to show that speech is intended and likely to cause imminent lawless action. Now, our sensibility of what is imminent and what is likely may change over time as we see the way things happen on the internet. So if you see a series of people getting doxxed and then certain things happening, if you see certain challenges or incitements on the internet leading to results, then our understanding of what imminence is may develop. But I think we're still applying the same standard. I think the threat one, the true threat standard, can be even more challenging. Because here again, you have to say, would a reasonable person take this as a genuine expression of intent to do harm? And there's this huge movement out there saying, oh, well, everyone gets threatened on the internet, you can't take it seriously. But I mean, some threats are actually terrifying. Some threats, and we're not all similarly situated about how terrifying they are. So that is another one where I think our sensibilities develop over time as society changes. I don't think there's anything magical that prevents our sensibility from developing to the point where, okay, I've been on the internet 20 years now, and now I have a more developed sense of whether someone really means me to be afraid or not. And if they mean me to be afraid, if they intend it to be taken as a sincere expression to do harm, then that's a true threat.
I think we also have to look at, and I struggle with this very much, I don't know where I come down on it, but we have to, I think, at some point, reimagine what we think of when we talk about public figures. The things that you can say or do or whatever to me, I have been a limited purpose public figure pretty much for 11 years now because of both law, right? So that's, if you're a law student, you probably heard of me, know who I am, whatever, and within that context, by all means, call me fat, it's fine, right? Now I'm at a point in my career where I'm kind of a wider public purpose public figure, and I'm feeling some of the, I have a new alarm system in my house, right? Like these things you learn that you have to do. I've chosen to put myself in that position, I guess. What about a person that just has 100,000 Twitter followers? They don't have a specific they don't have a specific job, they don't have a specific thing that they're doing, they just have 100,000 Twitter followers. Is that person a limited purpose public figure, or is that person an entire? And if they're not, then what about a million? What about what is there a point where you're only a public figure on Twitter, but you are such a public figure on Twitter that people can say all kinds of crap to you? Versus, and this is where I go to your doxing issue. This is how I'm trying to parse your doxing issue. If you're just like a guy playing a video game on Twitch, and people are swatting you and doxing you, that should be a crime, right? We should do that. That is an invasion of privacy crime. If you're doing it to me, I do everything I can to keep my address hidden, but you can find it. It's findable, and I'm a public figure, so I guess that if you want to say oh, go protest at Elie's house, if that's what the Tucker Carlson Brigade wants to do, I guess I would have to accept that, right? So how do we see what I'm saying? I haven't quite figured out where I want to come down. But how do we figure out who's a public figure for what when it comes to these things that if it happened to a private person, we would clearly understand as an invasion of privacy?
Does Michael have an ID card you yet? It's actually kind of just.
I'm going to take anyone from the back. So very back.
I'm wondering if you're concerned about government maybe doing an end run around the First Amendment by influencing social media companies to self-censor. Is that something that you spend any time thinking about?
Are we concerned that the government is doing an end round around the First Amendment by convincing social media companies to self-censor? It's weird because they're not convincing the social media companies to self-censor, right? They're convincing the social media companies to allow their side to have free reign, right? Twitter has said that the reason why they can't stop, people who talk about sex trafficking and that kind of the way that they stopped, terrorists like ISIS is because they would catch too many Republicans. Part of the problem is that the Republican Party has gotten to a point where we're not talking the same language, right? And so what the government is doing, controlled by Republicans now, is to encourage them to let the Republicans go and say what they want. And I imagine that if a Democrat gets in charge, they'll be trying to encourage the social media companies to not let the Republicans say anything, right? So I don't know that they're trying to make an end run around the First Amendment. I think they're both in their own ways just playing politics through other means. The responsibility and role to me still goes back to the tech companies, and they have a, I would say, moral obligation. I'm not sure I would say legal obligation to try to not screw everything up for everybody.
I would say that I'm not as worried simply because I think we're at a fairly high watermark in terms of First Amendment protections right now. All the decisions are really going in favor of robustly protecting the First Amendment, and even the types of judges who have been appointed by this administration or favored by the Federalist Society and conservative forces tend to protect that. They don't tend to mirror the anti-First Amendment, anti-media drumbeat that you get from political conservatives as opposed to judicial conservatives. So I have a limited amount of worry about that because of how strong the law is, I think, to protect them from those efforts. I'm more worried about 50% of America thinking, that everyone who speaks differently than me is terrible.
In the platform.
So I would agree that the courts are usually available to the powerful. And I was just wondering if you think there's any practical change in what we're seeing given that people cannot crowdfund what's normally a defense fund, suggesting that. But crowdfund legal action using social media, does that actually change the balance of power in the legal record?
I don't know if it changes the balance of power. It's just Walt Disney World for hucksters, though. It's a great way for con artists to get people to send them money to do stupid lawsuits. So I don't know if it really democratizes litigation that much. Litigation remains ludicrously, unsustainably expensive. And I think probably what would democratize it more would be broader education on how the system works, better resources for like pro-se clinics and things like that, and like Elie says, anti-SLAPP laws. The truth is that unless you've got a gigantic following, even your typical GoFundMe is going to be a drop in the bucket to litigate. Unless you've got 1 million followers, your GoFundMe is probably not going to generate enough to litigate for more than, say, 6 weeks.
Thanks for being here. So I'm really interested in the intersection between the First Amendment and school prison pedophile stuff. And so, as we've seen, all too many, mass shootings are committed by young white men, who in some cases have, written screeds and manifestos documenting their white supremacy and misogyny. But young people of color are too often over police for posting pictures of, themselves holding a gun, for example. And so, Ken, if you think the proper response is social change, my instinct is like, okay, so we educate police officers on cultural competency, but like, what else is there?
How can I put it diplomatically? I'm a little skeptic on the educated police officers part of that. Yes, sure. The question is, we're really worried about violence in our schools. There was a shooting at a school not too far from me this past week, and my daughter's school was on a lockdown 3 weeks ago. And what about the fact that on the one hand, we'd like to watch out for these warning signs, these scary screeds, manifestos and things, but on the other hand, we know that the more you put cops into the school, the more that tends to fall disproportionately on black and brown people. And the more that they are much more disciplined, expelled, put in different classes, things like that. Unfortunately, school speech rights is one area where we have not seen the robust growth of First Amendment rights. In fact, there's been a retread. We've retreated from the high water mark, which is probably Tinker versus Des Moines and and generally students have fewer free speech rights than they used to, and there are more theories and excuses and wiggle room by which their speech can be punished. I think we need a generally more a broad social skepticism about the value of resource officers and cops on campus, because I think we've seen from a lot of recent tragic shootings that there's not a whole lot that they can or do to stop the shootings from happening or to mitigate them. And when the more you put cops on campus, you get into the, when you're a hammer, everything looks like a nail syndrome. So I don't know if it's necessarily accomplished by educating cops. I think it's accomplished by trying to promote, and this is very difficult in the United States of America, a skepticism that law enforcement is always the right tool to deal with it.
So here's where I go very, very much pro First Amendment, right? Like I totally agree with Ken. I think he said it exactly right. Of all of the places where we see First Amendment running roughshod over what we normally think is decorum, school, the place where we should have the most of it, is where we see the most retrenchment, especially in high school, and it's done under the auspice, under the guide, in the same way that so many of our rights were lost after 9/11. They are using the school shootings to take away the rights of students at schools who are the victims of school shootings, not the perpetrators, 99.999% of it, right? And so you're absolutely right that we see over-policing of black and brown speech or whatever. We see over-policing of just normal high school chatter because people are so over the top afraid of spotting the next school shooter. The problem with school shootings has nothing to do with the First Amendment, it's the second one. And if we go and deal with the second one, if we go and stop the flow of guns to our young people, they can say whatever the hell they want.
And the thing is that when you reduce student speech rights because you're worried about school shootings, that's not what it's used for. Most of the action has no logical connection to school shootings. It's people trash talking each other on Facebook, right? And that's one of the emerging First Amendment school speech issues right now is when does the school have a right to discipline your kid for something they say on social media on the weekend? When does that have a connection with campus? What does that connection have to be? So that's one of the emerging areas. And again, I'm not in favor of giving them more freedom to punish.
Do you know how much time I spent in high school threatening to kill Jason? Who was, depending on the semester, like either top of class or second to me, and he's been like, if you thought I was like Jason, I'm gonna kill you. Like, I hope your family burns in a fire. Because I didn't like Jason. Jason didn't like me. We used to talk crap at him in this nerdy kind of way. Like, all the time. It was fine. We're shooting by you nerds. Like, it's, like, we just have to, like, we really need to, like, and it goes into, like, some bullying issues as well. Like, we need to step back from policing how hormonal teenagers talk to each other and step up getting the guns out of their hands.
So here's what we're going to do. We're going to take one more question, give you all the chance to do some wrap up, and then if there are more questions beyond that, I imagine you all will stick around for a little bit after this. Anyone want to ask a question? Sure.
So I think the true threats doctrine, the development of the true threats doctrine over time, is one of the places where the reasonable, straight, white man viewpoint has really inhibited the doctrine. And I think that comes out really strongly in IIED and in First Amendment cases. And at the same time, we have to be careful about not authorizing the law to attempt to make up for people's general hurt feelings. Can you guys riff on this idea and also bring it back to the First Amendment specifically? If we did that better, if we had a more comprehensive sense of the true threats doctrine that was more person-based, would that redeem the First Amendment side? I mean, would that enable us to not make so many other hard choices? Yeah. So I kind of go back to imbuing the true threats doctrine with some understanding of like recent history and objectivity, right? Like there are things that a person can do, there are things that a person can't do. Let's start with the things that a person can't do, right? And let's get like, I'm gonna punch you into the sun. Well, you're not, because that's not how physics works. Okay, so we're all gonna deal with threats that like you actually could, like at the very least, a true threat has to be something that is true, something that could physically happen, right? Let's go a little bit further than that. Let's say it's something that has actually happened to the person or the group that you're talking about, right? So like I would love to live in a world where we viewed threats against women a bit differently than we view threats against men, simply because we know that violence against women is a thing that's going to happen in these certain kinds of situations and whatever. So that when you are the drunken ex-husband threatening to kill your wife, we take that a little bit more seriously than if you are the teenage mean girl threatening to kill your rival for the school prom, right? Like we, and again, where I say my problems are is that it requires like people of good faith and good intention to be interpreting these laws. But there should be an interpretation that allows us to understand that there are certain people who, by nature of their immutable characteristics, are at more risk, and there are certain things that those people get threatened with more often that happen to them more often, that we should try to stop happening before they wind up chopped up in somebody's goddamn garage.
So,
True crime without Mystal.
in law and other areas, we apply a reasonable person test explicitly considering the position that the person's in. So sexual harassment law, right? When we apply the reasonable person test, would this be offensive to a reasonable person? Would it be offensive to a reasonable person in the position that this employee is in? A reasonable woman in this situation, a reasonable man in this situation. I'm not sure that the First Amendment prohibits us from having that type of sensibility in true threats cases. I honestly don't know whether a court has explicitly contemplated that. But I think that we could say, would a reasonable person in this position, whether it's the battered wife or whether it's the kid with an abusive parent or whatever, would a reasonable person in this position find this to be a sincere expression of intent to do harm? I don't have a problem with that. I think that, however, all of these situations where we try to get into each other's head and see each other's perspective are very challenging. And they're one of the danger areas of the First Amendment, because again, we have these vastly different cultures and vastly different sensibilities, and what seems like a threat to one person may not be intended that way or perceived that way in the other community. And my sense is that that problem will generally not work to the detriment of people who look like me.
No, it's clear. Ken's clearly right about that aspect, right? And you can see me kind of wrestling with that, right? Because I absolutely know that if we change the doctrines along the lines that I'm talking about changing them, then that's going to make it harder for my 2 African American sons to walk through this life without pissing the wrong person off, as opposed to easy. Right? I get that it's a kind of like real, like at a very core fundamental level, Ken is absolutely right about that, right? The issue is that my sons' lives are already pretty freaking difficult, right? And so, like, if they're going to be difficult anyway, let's at least not let's not fool ourselves that we're helping them by making it easier for the Klan to hold around. And see.
Well, hi, Elie, you've been fabulous. Thanks so much for this engaging discussion. Do you have any final comments you want to make?
I'll close with a short story
Oh,
about
God.
why.
All right, let me do this before a story. I know it. Without stepping on the story, I will just say that I think that it's critically important. Everybody who cares about this issue, like deeply cares about this issue, cares about it three-dimensionally. Like, do not fall for the Twitter trolls. Do not fall for the absolutism on either side, because you will hear people online, in your lives, whatever, say really, really dumb things about this issue. And it's on you, especially the law students here, to be out there as advocates for something reasonable. Ken, I think, to his credit, when the thing came up, tweeted at Rashida Tlaib, hey, love you. This is not the battle you want to fight here, right? You're a little bit off base here. I love what you're doing, and I understand, And he took a lot of crap for that, quite frankly, from me, included. But right. But like it is on you guys. It's on all of us to try to be advocates, to try to push back against the stupidity around this issue, because it is real and it is out there. So that's.
I think that people who, like us, who advocate for broad free speech rights, that winds up permitting ugly, terrible things to be said, that do tend to fall more heavily on some groups, have a moral obligation to push back against that. Even if we're not pushing back against it with the law, that we push back against it in our lives, and recognizing the harm that speech can do is not the same as saying that it should be prohibited. I come at this from a place of great skepticism of the government. So I'll close with the story of Sidney Street. Sidney Street was a bus driver and a World War II veteran, a decorated World War II veteran. And one day in the 1960s, Sidney Street turned off his radio. He went into his drawer and he got out the 48-star flag of the United States that had been draped over his father-in-law's casket. And he took it down onto his nearest street corner in Brooklyn, and he burned it. Before he burned it, he laid down a newspaper on the ground so that the American flag that he had fought for would not touch the ground. He did that because he had just heard on the radio that Medgar Evers, in his march against fear, had been shot by a racist. And he said that if they can do that to him, then the flag doesn't mean anything. But America finds Sidney Street's expression of outrage more threatening than it finds the tendency of people to shoot people like Medgar Evers. And that's why I firmly believe that it's so important to have very rigorous rules that often permit speech that I despise.
Thank you. Let's give everyone a
Where's the wine? Thank you. Thank you for coming. Cheers.
Do we have other mics
I'm gonna
on
go
them for
outside.
the podcast? What's that?
Any questions outside?
Were they mic'd for?
I didn't hear back from that, so I didn't know if you guys, I didn't know if you're recording it or is there
Well, I
sound?
am, but there's going to be ambient noise because I only use the boom.
Oh, okay. Gotcha. Yeah, that's easy. I mean, we could tap into that. I mean, for future ones, we can tap in.